Hi, Bill Henshaw back with you again, the head constitutional kook. The subject for today is subpoena power and how to use it. It's a beaut. Invoking our right to use the subpoena power of the court is another recent development in my programs to attack the bastards, not only in traffic court, quote unquote, the primary focus of my efforts to date, but in any setting in which the agents of the de facto government claim to have authority over you at all. A subpoena is the court order to produce witnesses and or evidence which we have the right to have to prepare a defense. Yet the local dumbass never responds to any of the documents we file, if we get them filed at all. And with no way to put on a defense, this even offends the due process clause of the non-existent 14th War Amendment. This will be particularly effective in any criminal setting, most especially when the local dumbass doesn't even acknowledge our demand for a bill of particulars, let alone provide the required answer to the nature and cause of the accusations, aka jurisdiction and venue, of the court, definition of the elements of the quote-unquote crimes charged, and most importantly, the identity of the injured party, for the purpose of invoking our right to confrontation and cross-examination. At first glance, especially in a traffic quote-unquote court, let alone a tax quote-unquote court, that the police officer, aka law enforcement thug, is your accuser, nothing could be further from the truth, as the 9-0 farts, the U.S. Supreme Court, have ruled that a cop has virtually absolute immunity for any and all perjury. Cases Briscoe v. Lehue, 460 U.S. 325. You can look it up. It ain't me saying it. This is because in my 4 decades in the trenches has established that the cops are simply not trained in the scope of their authority, primarily due to the failure of the territorial governor to perform his sworn constitutional duty to see the laws are faithfully executed. All too typical, an example you will learn from the acquisition of my modestly priced constitutional defense document packets is that a law which states that, quote-unquote, no person shall drive upon the highways of the state without a license issued under this code. There are at least 3 big problems here. 1, that a person described in such a law must be identical to the quote-unquote person described in Section 1 of the non-existent 14th War Amendment, the only birthright citizenship recognized by any department of the de facto National Socialist government, which can only mean an artificial corporate entity like IBM or Enron, and there is no question about this. 2, with there being no states, as mentioned in previous video, this term is undefined. We don't know what a state is within the meaning of the statute. 3, that the legal definition of license from Black's Fort Law Dictionary, the one these bastards use in their courts, is permission granted by competent authority to do an act that without such permission would be illegal, a trespass or a fart tort. All this does is defeat any and all vehicle code statutes as a matter of law, which accounts for why 1, the local dumbass never enters our bills of particulars. 2, most if not all of the supposedly neutral traffic commissars get apoplectic, displaying outrage and anger while trying to intimidate a pesky pro-per litigant, since they sense, if not know, that acting without jurisdiction they will be personally liable for their acts and any ensuing and civil case, and will bring a long overdue end to the scam of traffic courts. Accordingly, the governor is your accuser, and why a subpoena should compel him to testify in your case. But my ongoing research hasn't disclosed any court decisions on this issue, especially by the 9-0 farts. I believe that this is a winning issue that should be assertively presented, noting that the clerks of court are required to file subpoenas and let the cow chips fall where they may. Copy of this script is cheerfully available on request at unincourt@gmail.com. Please like this video and tell your friends. Thank you.